Lawson, Dr. Bonadev,
Here.
Dr. Kraus,
Here.
Dr. Levine, here. Denise Pine, Ms. Sutton Wills, here. We have a quorum.
All right, the first matter we have is an oral argument on judicial remand. We are hearing from counsel that they are not going to be present for this oral argument because they have it miscalendared for the wrong day. I think we should have some discussion as to whether or not to continue this matter for any reason. My recommendation would be that we proceed. We are all here. We made the effort to be here on the right day. We've got written papers from both parties, and we've got the order from the court that directs us as to what to do, but happy to take everybody's thoughts.
Agree.
Yep, let's proceed.
All right, let's proceed.
All right, so Dr. Firestone, this is...
Give the judge a moment.
Right, go forward. So they will consider your written argument, okay?
I
Okay,
will turn it over to the judge.
thank you. We are on the record in the matter of the second amended accusation against James Edward Odorisio, MD. And this is Medical Board case number 12-2011-217415 and Office of Administrative Hearings case number 2017-070121. Today's date is July 26, 2017. My name is Jill Schlickman. I am an administrative law judge with the Office of Administrative Hearings, and today I've been assigned to preside over this hearing. At this time, I will take the appearance of the Attorney General's office. Attorney for the record, please.
Carolyn Evans on behalf of the complainant, Medical Board of California.
All right, thank you. I want to note for the record that this hearing was noticed for oral argument for today at 3 p.m. here at the Embassy Suites in South San Francisco. It is now 3:18 p.m. and neither Dr. Feinstein nor Dr. Odorisio have appeared. I did contact Dr. Feinstein's office, spoke with Dr. Feinstein, and was advised that he had miscalendared it and that he thought that the hearing was tomorrow at 3 instead of today at 3 p.m. There is a proof of service in the board's records that shows that the hearing was clearly noticed for today at 3 p.m. All right, and the board
I would just correct that the attorney's name is Dr. Firestone and not Dr. Feinstein.
I'm sorry. Thank you, Dr. Firestone. Thank you. The board has considered Dr. Firestone's request for a continuance to another date and has decided not to postpone the hearing. It was properly noticed. All right. So, Ms. Evans, you will have 15 minutes to make your opening argument, and then you have another 5 minutes, I guess, to make your closing argument, since we don't have Dr. Firestone here to make his argument. I will also note for the record, however, that Dr. Firestone did submit a written argument for the board's consideration, and that is in its files. Okay, so I'm going to go ahead and invite Ms. Evans to begin her argument.
Thank you, Your Honor. This case is before the board on remand for a very limited purpose, and that is to determine what the appropriate penalty or discipline should be in light of the Superior Court's most recent April 2017 decision, and in light of the findings that were sustained, which were the majority of the board's findings. And in this assessment, the board is constrained by the administrative record. So although in respondent's briefing he mentions lots of things that are outside of the administrative record, such as probationary reports and performance and pace, and so we would be objecting to the board considering those things because they're not properly part of the administrative record. With that said, this case has been before the board several times and has been exhaustively briefed and argued, so I'm not going to elaborate on the underlying claims much more than to say that this case did involve the respondent committing significant quality of care violations with respect to 5 patients, and it also involved 2 patient deaths and inadequate and inaccurate medical record keeping. And so if we turn to the Superior Court order, what we see is that the judge said that the board cannot require that the respondent have a practice monitor present during carotid procedures, but the judge did say that the board could reaffirm its original decision, the August 2015 decision, and that was clearly stated. As you recall, the original decision contained a 5-year term of probation with a practice monitor provision, and it was a standard provision, I should mention, remedial education and no solo practice provision. Now, given the grave circumstances of this case, the serious nature of the deficiencies, it's our position that the original penalty is still the appropriate discipline, and that is required for purposes of ensuring that the public is protected and for the other purpose of ensuring that the respondent gets fully rehabilitated. Furthermore, the disciplinary order in the original decision is what is the minimum that the board's disciplinary guidelines require anyways. So in his briefing, respondent notes that he's made changes in his practice, and that's commendable, and we are glad that probation is working and doing its job. But nevertheless, a 5-year term of probation with the special terms and standard conditions is still required because the board needs to assure itself that not only has the doctor learned some new lessons, learned from his mistakes, but that he is also going to be able to sustain those changes over a significant period of time. The board needs to make sure that those changes become ingrained in his practice and that these are permanent fixes. And so a period of 5 years with board oversight is going to ensure that that is what happens. Now, I want to point out that that the respondent is requesting that you, board, today reduce the term of probation from 5 years to 2, and that you also make some changes or change the conditions, including the elimination of a practice monitor. And I just wanted to let the board know that that is inappropriate for the reason that the respondent is conflating what this proceeding is. This is a limited remand. And again, we're constrained by the administrative record. And he's treating this as a petition for early termination or modification of terms, which is under Business and Professions Code section 2307. And the 2 hearings are apples and oranges. So this remand hearing, again, is limited solely to determining what is the appropriate discipline in light of the court's order and within the confines of the administrative record. And a petition for early term and modification is the statutory remedy that the respondent has so that he can present, his evidence of improved performance on probation. And that would be where the board can look at things outside the record, such as his quarterly probation reports, his practice monitor reports, PACE performance, etc. But the 2307 hearing is what allows the board to properly vet his performance on probation. This is not that forum. This is not that time and place to decide those issues. So again, we commend the doctor for making the changes that he has represented that he's made, but the board's primary mandate is still public protection, and the only way for the board to really maintain or to ensure this is to maintain oversight over the doctor by way of a practice monitor and to give him enough time to really make those permanent changes, and having an objective third party to be able to report back to the board and confirm that he is exercising, that appropriate judgment and that he's following the standard of care is critical for the board. So based on today's oral argument that we presented and our briefing, we would recommend that the board affirm its August 2015 decision. Thank you.
Thank you. All right. Ms. Lawson, did you have any questions for Ms. Evans? Yeah. All right. Dr. Nanadev, did you have any questions? Okay. How about Dr. Kraus?
No questions.
Okay. Dr. Levine? No. And Ms. Sutton-Wills? Okay. All right. Then I think being there's no questions, unless you had something else, we'll close the record.
Nothing else to add, Your Honor.
All right. Thank you very much. Then we are off the record.
Is back in open session for agenda item 3. Oral argument on non-adopted proposed decision, John Derek Van Dorn, and I'm going to turn it over to Judge Schlichtman.
Thank you. All right, we are on the record in the matter of the petition for reinstatement of John Derek Van Doren. This matter has been assigned Medical Board Case Number 800-2015-017304 and Office of Administrative Hearings Case Number 2017-070123. Today's date is July 26, 2017. My name is Jill Schlichtman. I'm an administrative law judge with the Office of Administrative Hearings, and today I've been assigned to preside over this matter. At this time, I will take appearances for the record, starting with the Attorney General's office.
Good afternoon. Nicholas Schultz, Deputy Attorney General, appearing on behalf of the people.
Okay.
Martin DeSica, representing the petitioner, Mr. Van Doren.
All right. Thank you. Could you spell your last name for me?
Yes, P and Paul, A-S-E-K-A.
All right. Thank you. Okay, so each side will be given 15 minutes for opening argument, and then each side will be given 5 minutes for closing argument. In making your presentation, bear in mind that the board members have read your written argument and that the argument may be based only on the existing record. After the hearing, the board will meet in closed session for deliberations. I will not announce its decision today. You will receive that in the mail at a later time. Okay. So, at this time, we will have Respondents' Counsel begin her argument. Go ahead.
I thank the board and your honor for the opportunity to discuss why we believe the proposed decision granting reinstatement in this case should be adopted with minimum modification. Although we do not know the specific reason the board rejected the proposed decision, we have been notified that the Attorney General's office will provide for modifications to the conditions for probation if reinstatement is deemed warranted. We concede to those modifications: the condition abstaining from the use of alcohol and the condition to abstaining from the use of alcohol. Mr. Van Doren has almost 10 years sobriety, and he's been sober since December 8, 2007. Therefore, including these conditions is not a concern. The other two conditions, or modifications, include extending the probation term from 3 years to 5 years, and requiring a clinical competence assessment program, or, in the alternative, a psychiatric evaluation and a 1-year residency program. We disagree with these modifications. But before discussing our reasons for that, I'd like to go through a little bit of the history of the case. Mr. Van Doren was initially disciplined in 2004 for using marijuana and cocaine, abandoning the patient by taking a break while the patient was under anesthesia, and failing to timely respond to his pager, as well as inappropriate and unprofessional behavior with hospital staff. Due to this misconduct, Mr. Van Doren was placed on probation for 5 years. Only a few months into that probation, he relapsed and used cocaine. Due to that use, an accusation and petition to revoke was filed, and his probation was extended to 7 years, and he was placed on a 1-year suspension. Part of that probation was to complete the diversion program. Due to the relapse, the diversion executive committee required an approved professional treatment program to be completed. Mr. Van Doren was unable to afford such a program, or one of the approved programs at that time, and therefore was terminated from diversion for not enrolling. The termination was then grounds for revocation of his probation. A petition was filed, and Mr. Van Doren did not contest that petition, and therefore his license was revoked by default on April 30th, 2000. Mr. Van Doren admits the seriousness of the misconduct. Yet, the law provides the opportunity for a physician who has struggled with addiction and made mistakes to prove himself rehabilitated and worthy of life insurance. This is a model rehabilitation case because of what Mr. Van Doren has done for his recovery since revocation. Mr. Van Doren has been sober for over 9 years, or close to 10 now, and has since December of 2007 completely given himself over to the recovery process. Despite his personal commitment to sobriety and activities in AA and NA, he knew that the word of an addict was not going to carry much weight. So in 2010, he sought out monitoring and created a system of accountability for himself. As the medical board at that time no longer offered a diversion program, he worked with the California Dental Association Wellbeing Committee by signing a 5-year contract, which required attendance in individual and group therapy sessions, AA meetings, and random drug and alcohol testing. He began seeing his therapist bi-monthly and his psychiatrist quarterly, which actually he continues to this day. He even maintained his program when he relocated to New Mexico for a year and a half in 2013 by working or partnering with the New Mexico Monitor Treatment Program for physicians, and then returning to California in May of 2015, he picked up with the California Dental Association program in the fall. As you may be aware, this is not Mr. Van Doren's first petition for reinstatement. In 2010, he was petitioned for reinstatement, but was denied, but he did not give up. Rather, he continued to dedicate himself to his recovery, confident that this would eventually prove that he was in fact rehabilitated. The decision denying his petition noted that there was insufficient evidence to demonstrate rehabilitation, as his recovery had not been monitored for enough time to prove a consistent commitment to sobriety. After being denied reinstatement, he took the conclusions of the ALJ to heart. He sought reinstatement again after completing now 6.5 years of monitoring in order to evidence the personal commitment that he's had to his sobriety for the past 10 years. At the recent hearing, Mr. Van Doren presented over 6 years of negative random drug and alcohol testing and showed evidence or presented evidence of his extensive support system by submitting 23 letters of support from and testimony of supervisors, colleagues, and members of the AA and NA fellowship. Also, Dr. Gregory Skipper, a certified specialist in addiction medicine, testified in hearings regarding Mr. Van Doren's ability to practice medicine. After comprehensive testing, psychological testing, and a thorough interview, Dr. Skipper concluded that Mr. Van Doren was in fact fit for duty. He testified that Mr. Van Doren's alcohol use and cocaine use disorders are in full sustained remission, and that Mr. Van Doren poses a low risk of relapse. This conclusion was also supported by several other specialists in addiction medicine that wrote on behalf of Mr. Van Doren's reinstatement. Administrative Law Judge Lori Perlman found clear and convincing evidence established that Mr. Van Doren was in fact rehabilitated. And the goal of public protection would be served by a period of probation with appropriate terms and conditions, which she specified in that proposed decision. At this juncture, I'd like to return to the two modifications that we disagree with. First, the request that the probationary term be extended from the 3 years that Judge Perlman suggested to 5 years. Judge Perlman was there at the hearing, heard the testimony, and reviewed the evidence, but she determined that a 3-year probationary term was sufficient to protect the public. Mr. Van Doren has completed now 6.5 years of monitored recovery, similar to that which the board requires through probation. Combined with the additional 3 years that Judge Perlman imposed, Mr. Van Doren will have completed a total of over 9 years of monitoring and will have been sober for over 13 by the time he's released from probation. Mohan Nair is an addiction medicine specialist and forensic psychiatrist who evaluates physicians with addictive disorders for the medical board. You may be aware of his work. He wrote a letter on behalf of Mr. Van Doren and was submitted into evidence that in his letter he cites that a time frame of about 5 years of continuous abstinence puts a physician among the group of physicians that are generally considered to remain abstinent and successfully re-enter the profession. He goes on to state that there are no studies that show proven abstinence past 5 years confers greater levels of safety and recovery. Now, discipline should only be imposed if that discipline is necessary to protect the public. There has been no evidence to suggest that an extension in the probationary term in this instance would provide or offer further protection. Therefore, the requested modification that the probation term be extended should be denied, as it would become punitive rather than preventative. The final modification that's being requested is that Mr. Van Doren is to be required to complete a clinical competence assessment program as a condition precedent for reinstatement, or be required to undergo a psychiatric evaluation combined with a 1-year residency program. I'll first turn to the first alternative here in this kind of double possibility. The condition requiring the assessment program, which most commonly here in California is the PACE program, was specifically considered at hearing. Mr. Van Doren requested that in lieu of his condition that he be allowed to take the special purpose examination, or the SPECS exam, to prove his competency. This is not because of concerns that he would not be able to meet the PACE requirements or standards, but rather because of the extraordinary expense of these types of programs. As Mr. Van Doren has not been able to work as a physician, he is financially unable to afford such a program. The board has other mechanisms to ensure competency, one including SPECS, reporting by the worksite monitor, which is required by the proposed decision, and required educational programs in addition to the standard continuing education requirements, catered to areas that he may need refreshment. If imposed, the PACE or equivalent program would effectively deny his reinstatement because he just simply cannot afford to receive. The proposed alternative to this type of program, as presented by the Attorney General's office, is a psychiatric evaluation in a 1-year residency program. This alternative will also place unwarranted and unintended hurdles to reinstatement. Requiring a psychiatric evaluation is redundant. At hearing, uncontroverted testimony of Dr. Skipper was presented regarding specifically Mr. Van Doren's ability to practice medicine safely. He conducted a thorough evaluation and the requested psychological testing to determine whether he is in fact fit. He concluded that he was. In addition, the proposed decision, as it reads now, already imposes a requirement of a thorough clinical evaluation in which Mr. Van Doren will be evaluated as to whether he is a threat to himself and others, and will include recommendations for treatment, practice restrictions, or other recommendations, and which, if deemed necessary, a psychiatric evaluation could be defined as that. The second prong of that alternative is a 1-year residency, which makes successful completion of probation out of the control or out of the hands of Mr. Van Doren. Acceptance into a residency program is not guaranteed. Also, many residency programs require an unrestricted license, and that would make it impossible for him to ever successfully complete probation. Although Mr. Van Doren is and did testify at hearing, he is very interested in completing a residency or fellowship program in addiction medicine. He's now preferred field of medicine he was trying to re-enter. To impose that as a condition of probation is unfair and places an undue hurdle on successful completion and reinstatement if it is in fact a condition precedent. Although it is true that Judge Perlman's decision slightly deviates from the model disciplinary guidelines, those guidelines are just that, guidelines. And variations are to be made to accommodate unique circumstances of individual cases. Judge Perlman considers the extensive evidence of rehabilitation and recovery, along with the financial hardships that standard conditions would impose, and these factors are reflected in the conditions she included in her proposed decision. Thus, we request the Board adopt the proposed decision with the slight modifications to include the 2 conditions requiring abstinence from the use of alcohol and controlled substances, which we concede to definitely be the probation program. At this point, I think we have some time left. I was going to allow Mr. Van Doren to address the panel directly and answer any of your questions. Oh, please.
The truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay. And so you just have 1 minute left, except for your other 5 minutes. So did you want to wait and have?
We'll wait and I'll provide him time at the end of the letter.
Okay. All right. Okay. So then we will move to Mr. Schultz.
Thank you, Your Honor. And to members of the panel, opposing counsel, thank you for being here. I appreciate opposing counsel's in-depth discussion of the facts and the procedural history of this case. In determining what disciplinary outcome should be imposed, the facts of the case do very much matter. This is not simply a case of substance abuse. The underlying misconduct that lands Mr. Van Doren in the position that he's in today stems from his gross negligence, repeated negligent acts, incompetence, as well as the substance abuse issue. I agree with opposing counsel. If you refer to page 8, conclusion of law number 8 of the proposed decision, Administrative Law Judge Perlman did find that the petitioner's consistent record of abstinence favored the reinstatement of his medical license. But very importantly, she also found that the protection of the public requires the petitioner serve a period of probation with, quote, appropriate terms and conditions. And I submit to you that the issue that we must decide today is whether the proposed decision as it stands contains those appropriate terms and conditions, and whether those terms and conditions adequately protect the public from the risk of future harm posed by Mr. Van Doren. The position of the Attorney General's office is that the proposed decision is deficient, and that in that it does not include necessary terms and conditions. Now, the administrative record before this body establishes a number of important facts. Number one, it establishes that the petitioner has struggled with a long history of substance abuse, and he has in fact found recent success. The record also demonstrates why the proposed decision is deficient. Let's begin with discussing the length of probation. As opposing counsel mentioned, the proposed decision imposes a mere 3-year period of probation. And there really are 2 considerations that I would implore this body to consider. Number one, pursuant to Government Code Section 11522, should a 3-year period of probation be imposed, the petitioner would be entitled to petition for early termination of probation after only 1 year. And the fact remains that this outcome, that he could petition after only 1 year, neither protects the public sufficiently nor ensures that he will continue in his rehabilitation. Secondly, and I'll get to this more momentarily, it is a sharp deviation, not only from the model disciplinary guidelines, but the outcome that we see in many similarly situated cases. The second clear error in the proposed decision is the abstinence requirement, which I won't discuss much. I will note for the record that the omission of abstinence requirements is truly inexplicable, given that Dr. Skipper, the petitioner's own expert, concluded that he had a very severe problem with addiction and diagnosed him with severe alcohol use disorder, cocaine use disorder, both of which he found to be in remission, as well as major depressive disorder. And I don't mean to belabor the point, but the fact that opposing counsel does concede that this should be in the proposed decision is significant. Because while the proposed decision does include a clinical diagnostic evaluation and biological fluid testing, those conditions are rendered meaningless and ineffective without the abstinence requirements. So those absolutely must be included to protect the public. With regards to the clinical competence assessment program, I will just take this moment to pause and say the alternative that opposing counsel was discussing, the fellowship program coupled with the psychiatric evaluation, was really an effort by our office to give Mr. Van Doren a choice, at his insistence that he wanted to complete the fellowship program. But all things considered, if that's not what he wishes to do, the primary recommendation of the Attorney General's office is that he complete a clinical competence assessment program, as opposed to the fellowship and psychiatric evaluation. The special purpose examination, which I'll refer to as SPECS moving forward, as all of you know, is a computerized multiple choice test of current knowledge that is requisite for general undifferentiated practice of medicine. I submit to you that this test is appropriate for circumstances where a physician has held or recently held a license in good standing and unrestricted. But in this particular case, given that there are concerns about the petitioner's fitness to competently practice, SPECS should only be evaluated in conjunction with other information that's available to the board. As demonstrated by the record before you, specifically Exhibits 5 and 9 of the Attorney General's exhibits, the petitioner last held an unrestricted medical license in June of 2005. He last held a medical license of any sort in April of 2007. This means that he has not practiced medicine in over a decade at this point. And with all due respect to opposing counsel and the petitioner, I think there is a conflation of two very separate issues here. There is the issue of substance abuse and whether the petitioner has been rehabilitated from that point. But there's also the separate issue of this is a physician that hasn't practiced in over 10 years. We don't know what the status of his health is, both mental and physical. We don't know what the status of his skill set, medical knowledge, interpersonal and communication skills are. And that's why a clinical competency assessment program is so important in this particular case. As opposed to SPECS, a clinical competence assessment such as PACE or any other similar program would include a comprehensive assessment of both his physical and mental health, including a physical examination and microcog evaluation. It also includes an assessment of the 6 domains of clinical competency, including patient care, medical knowledge, practice-based learning and improvement, system-based practice, professionalism, and interpersonal skills and communication, as opposed to a multiple choice test where the answer is quite literally in front of you, 1 of 4 or 5 options. The PACE program or any similar program would involve the careful observation and evaluation of the petitioner to evaluate for things that, quite frankly, a multiple choice test just can't evaluate, whether that is ethics and professionalism, patient care, or communication skills. And again, it's very crucial to understand that the petitioner hasn't practiced in 10 years. And so all of this, I do respectfully disagree with opposing counsel. None of these recommendations are punitive, nor are they meant to be punitive. The primary directive of this body, and the only consideration of the Attorney General's office in this matter, is what safeguards can be implemented to protect the public. And again, with all due respect, the petitioner is not entitled to reinstatement. It's a gift. It's an opportunity to demonstrate to this board, to the patients of California, and perhaps even to himself, that he is competent and ready to safely and independently practice medicine and to rejoin the profession. Now, with regards to some of the petitioner's arguments, let's begin with what is laid forth in his written argument. The petitioner submits that the proposed decision was well-reasoned and supported by the evidence. But if that were the case, why does the petitioner now concede that the abstinence requirements should in fact have been included, that they are appropriate? With regards to the length of probation, a 3-year period is a sharp deviation not only from the guidelines, but from similar circumstances. For example, a physician committing unprofessional conduct, gross negligence, repeated negligent acts, or incompetence pursuant to Section 2234 of the Business Code would be provided a 5-year period of probation under the guidelines. A physician found to have a mental or physical illness in violation of Section 820 of the Business and Professions Code, again, the guidelines provide for a 5-year period of probation. A physician that violates federal or state drug statutes or regulations, thereby violating Section 2238 of the Business and Professions Code, again, the disciplinary guidelines provide for 5 years. And the same arises with a violation of Section 2239, the excessive use of alcohol or drugs. The crucial thing here that this body must decide is whether there is such mitigation before it to reward a substantial downward departure from what the guidelines would otherwise provide. And again, I do believe that there is a conflation of two very related principles yet again. This idea of looking at the petitioner's length of sobriety and a period of probation, because again, the goals are very, very different. Probation doesn't merely serve to ensure that the petitioner continues to abstain. It also serves to further assist in his rehabilitation by ensuring that he is safe and competent to practice. With regards to PACE, as the board is well aware, the primary mandate is to protect the public, and that's why it is necessary as opposed to specs. And there are a few final points I'd like to address with regards to this issue of what sort of rehabilitation we want to impose. Petitioner asserted in his written argument that the administrative law judge heard testimony, quote, regarding the similarities to the two assessments, that being PACE and specs, as modes of proving that he is qualified to practice. But I submit to you that that is not correct. If you refer to transcript of proceedings, pages 171 to 172, what you will find is the petitioner discussed his understanding of specs. He discussed how colleagues of his had utilized specs in lieu of PACE, but there was no discussion of the circumstances of those physicians' cases. There was no testimony of anyone from the PACE program or other similar assessment program to discuss how specs tests for many of the same things or not, as opposed to the PACE program. With regards to the petitioner's claim that he's unable to pay the cost of the PACE program, I submit to you that there's no evidence in the administrative record before this body that that's the case. There was no discussion from the petitioner of his inability to pay. In fact, I would refer you to pages 93 to 106, as well as Exhibit 1 of the administrative record. This establishes, to the contrary, that the petitioner was gainfully employed throughout his period of not having a license, both working for his wife's background check company, which I believe he currently still works for, as well as a laser technician. Again, the petitioner's mere assertion that he can't pay isn't supported by the evidence. And I submit to you that when looking at this administrative record, there's no such evidence to make a finding that he can't pay for PACE. But again, it all comes down to the fact that it is a gift. It's an opportunity to demonstrate that he's competent and ready to practice. So in conclusion, the recommendation of the Attorney General's office is as follows. Should the board decide that the petitioner's petition for reinstatement should be granted, he should be required to complete a minimum 5-year period of probation, which does comply with the disciplinary guidelines and does further protect the public as well as assisting in his rehabilitation. He should be required to abstain from the use of both alcohol and controlled substances, and he should be required to complete a clinical competence assessment program as a condition precedent. The fact is that the petitioner his story has evolved as far as what type of medical specialty he plans to go into. He discussed a desire to go into the field of addiction medicine, but with absent a practice restriction, there's nothing preventing him to go back to the field of anesthesiology or any other field that his medical license would allow. Requiring him to complete the PACE program or any other comparable program inures to his benefit by making sure that he's ready to go back out there and that he is competent and safe, and it inures to the benefit of the public at large. But notwithstanding this recommendation, the board, of course, has the authority to deny the petition if it feels that the petitioner has not met the burden of clearly and convincingly proving that he is both rehabilitated and that he is entitled to have his license restored, and that it overcomes the board's prior adverse ruling. Thank you very much.
Before Mr. Van Doren makes a statement, I'd like to just redirect and focus on two things. One, the fact that the probationary period you can petition for early termination of probation should not be a consideration of whether probationary period should be extended or not. The petition is held in front of either a panel or an ALJ, and facts that exist at the time of the petition will be evaluated and a reasoned decision will be made whether at that point early termination is safe or is in the goal of protection of the public. So that will be decided if in fact he does petition. That is a decision that will be made based on the fact of the time, and is not a guarantee that he's going to be released any earlier than 3 years later. Second, I'd like to just briefly discuss the fact that although PACE does have this psychological evaluation component that SPECS doesn't have, that has been thoroughly covered by the experts that testified at hearing and submitted written letters in support of reinstatement, over multiple letters regarding his fitness to practice. Therefore, the question of him not practicing for 10 years is truly competency, which is what SPECS will cover, along with the educational courses that are outlined in one of the conditions of probation, number 7, to address areas that he may need additional training. And so if SPECS does identify any specific area that he does need additional training in or refresher courses in, then that can be required under condition 7. I'd like to give him some time, so I'll end there.
My name is John Derek Van Doren. Well, thank you for allowing me to do so, and thank you for representing me. I think you did a great job. I want the panel to have an opportunity to hear me speak. I'm not an attorney, but I am aware of the difference that has taken place in my life, in my thinking, and in my behavior since I was disciplined. When the board rightfully decided to revoke my license in 2007, I made a decision that I had to figure out how to live my life. And my recovery and rehabilitation has given me a freedom from any sense of self-pity or doubt about myself and about my right to exist. And I discovered that that I'm a part of life in a way that I hadn't been before. My recovery has provided me with a way of living that's based on principles, and it's allowed me to have a great relationship with a wife and my children that was missing before. I've been able to work in the operating room environment for an extended period of time. Certainly being a laser tech isn't the same as being an anesthesiologist, but I've interacted with the same people and had very similar stresses with needing to be on time and be set up and be available. So I think that I'm certain that my behavior, my ability to operate in this setting that I wasn't able to function in professionally in the past, that my recovery and rehabilitation have made that a comfortable place for me to be. However, I feel that my life and my recovery have evolved in a different direction. I'm currently working with the Coastline Behavioral Health in Huntington Beach, where I live, facilitating recovery groups there as a consultant. I'm working again with Dr. Mohan Nair as a records reviewer, and in fact he has provided me with airfare and hotel accommodations and registration to participate in the American Society of Anesthesiology's pain review in Chicago coming up next month, which I intend to do. My application, I do have an application for fellowship in addiction medicine, so that, you know, my entire life and my entire direction is set now in a course of being in the recovery community, sharing what's been given with me, the insight that the just right to exist as a human being is of paramount importance that I, as an addict, didn't really appreciate before. My behavior stemmed from insecurity about me and wanting people to like me and accept me, and uncertainty about that, and in combination with the loss of control of my desire to find pleasure and my desire to be rewarded, and the other effects that addiction have on the brain. You know, I wind up here today before you, but I currently am dedicated to recovery, not just for the obtaining of a medical license, but another opportunity to be in the profession, which I sincerely desire and want and believe that I'm prepared for. But I do that because it seems that this is the direction that my life is calling me, and I have, again, a relationship with people in the addiction medicine that I'll be able to better serve with a license. And that's really what I wanted to say. I wish that I had more time to be with you so that you could have a better look at me and opportunity to know me. I think that would be, you know, of great value to you in making the decision. So thank you for your time.
Yes, Your Honor, and thank you all again for your time today. I'd just like to address a few brief points and save any balance for questions. I do respectfully disagree with opposing counsel that this board shouldn't consider, well, I'll phrase it as what I think the board should consider. I think the board is absolutely entitled to consider the earliest opportunity at which the petitioner could petition for early termination of probation. I think that the board not only should consider that, but again, the disciplinary guidelines, and again, evaluating, is there such mitigation evidence present that there should be a departure from what the guidelines otherwise provide? Second, I would like to point to the petitioner's own admission in the course of the administrative hearing. If you look at the transcript of the hearing, pages 186 to 196, that's a portion of the petitioner's testimony. And at one point he said, and I quote, I may need training in order to be current in my ability to practice medicine, end quote. And I think that that admission is significant. I think that that shows you that the petitioner even understands it has been a substantial period of time. And whereas there are many cases where taking specs in lieu of PACE would be appropriate, I humbly submit to you that this is simply not one of those cases, given the substantial period of time that he has not practiced medicine. With regards to the PACE program, there has been this discussion of exactly what does the petitioner want to do should he get his license back. And I would note that the PACE program will evaluate him in either his current or intended area of practice. So whether he does intend to return to anesthesiology or enter a new area of practice, such as addiction medicine, there is tremendous value in having him assessed to determine his competency. And again, there is much more to the practice of medicine than mere medical knowledge. So very similar to how there's much more than to the practice of law than merely knowing the law. Professionalism, ethics, communication, in the instance of a physician, bedside manner. Those are all incredibly crucial aspects of the profession and things that simply cannot be evaluated in the course of the specs examination. But they can and are evaluated in the course of the PACE examination. And that leads me to my final point. And this really is an overarching trend. Whether you're considering the petitioner's claim that PACE would pose an economic burden, the reality is that protection of the public is paramount. It trumps any other consideration. It's not that this board or even my office cannot be sympathetic to the petitioner's plight, or that we cannot commend him for the incredible job that he has done and the rehabilitative steps that he's taken. But at the end of the day, we have to ask ourselves, what steps can and must be taken to protect the patients of the state of California? And in this particular case, This office, the Attorney General's office, is not here telling you to deny this petition, but we are here to tell you that should the petition be granted, should he be reinstated, the proposed decision as is deficient, and merely adding abstinence requirements does not adequately protect the public. I thank you all for your time. I'm happy to answer any questions that you have.
No, thank you.
No, thank you.
I'll just summarize and if you have a follow-up question. At the time, Mr. Van Doren had been on his own personal commitment to using the AANA fellowship along with other various groups to aid in his recovery. But at the juncture when he realized that he would want to seek his license again, he realized that some kind of monitoring and structure and accountability would be needed. And therefore, at that time, the medical board did not offer a diversion program any longer. Therefore, he sought out another program that did provide a similar monitoring system, such as the California Dental Wellness Association, which provided accountability. He has tested, he's had the 5-year commitment, and now he's actually been a participant for 6 years, over 6 years, but there was a year and a half in which he went to New Mexico and was under the New Mexico, basically the New Mexico board's diversion program for physicians. But because California did not have a physician diversion program, that is how he became involved with the dental assistance.
Yeah.
By the time he completes 3-year probation, he will have been monitored for 9 years. At this moment, it's been 6 years.
I just wanted to say that I've been participating in Caduceus, which is local physicians and other healthcare professionals in AA, International Doctors and Alcoholics Anonymous, and I met members of the Dental Wellbeing Committee and approached them about allowing me to participate in that program.
The